Hi, I'm Lori Cope, General Counsel of Topeka Public Schools. Today we're going to answer the top 10 questions about Section 504. Section 504 is a law that has been in effect since the 1970s. Despite that fact, it's still something that raises a lot of questions, specifically in schools. What I found during my career as a school attorney is that most of the time school employees understand general education and they understand special education, but they're not real clear on Section 504, which is kind of a little bit in between both. So hopefully in going through these top 10 questions, we're going to be able to get you the answers that you need so you feel comfortable dealing with Section 504. Okay, let's get started. So, best place to start is at the beginning. What is Section 504 of the Rehabilitation Act of 1973? Well, Section 504 is an anti-discrimination statute, okay? It is not an education program. IDEA, which is what implements special education in schools, is an education program, okay? That is not what Section 504 is. It is an anti-discrimination statute. It prohibits discrimination on the basis of disability. So schools cannot discriminate against any individual on the basis of a disability. It's designed to provide equal access and fairness in general education to students with disabilities, okay? One of the easiest ways to describe the difference between Section 504 and special education is 504 is merely meant to level the playing field, remove barriers that individuals with disabilities may have in accessing the general education curriculum, okay, or activities and those types of things. Where special education, there's a specifically designed instruction to allow them to do that. So special education, usually we're adding things, where Section 504, we're removing barriers, okay? There's no funding attached to Section 504, but there is a penalty for violation that can result in a loss of all federal funding. So like special education, there is money that is given to the district to help with special education. The same cannot be said about Section 504. There is no funding attached to it. However, we could lose federal funds if we do not comply with Section 504. Okay. Section 504 applies to any program or activity that receives federal financial assistance, okay? When Section 504 was first put into place, it only applied to those programs that specifically received federal funding, where now if a school receives any federal funding at all, if they get $1, all of their programs and activities are subject to Section 504 requirements. So we cannot discriminate on the basis of a disability in any of our programs or activities, and nor should we. But to be clear, under the law, we are not able to do that. Okay, look at this. We're moving right along to question number 2. Who is protected under Section 504? Well, it's an individual with a disability. So who is an individual with a disability? Well, it is someone who has a mental or physical impairment which substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. Okay, so has a mental or physical impairment which substantially limits one or more major life activities. So they currently are dealing with that. Has a record of such an impairment. So an individual who had cancer but are now in remission, they would still be considered as an individual with a disability, or is regarded as having such an impairment. Okay, so somebody says, wow, that person is bipolar, that student is bipolar, and they're not actually diagnosed with that, or may not even have it, but, or, maybe even better, they're ADHD. If we regard them or treat them as having such an impairment, that would also qualify someone as an individual with a disability, which would mean they would have protections against any type of discrimination. Quite a number of years ago now, it's amazing how time flies, but quite a few years ago, I would say 4 or 5 years ago now, there was the ADA Amendments Act, which broadened the scope of coverage. So it's the ADAA, lost an A there for a second. It broadened the scope of coverage, okay? So now under the ADA, which we get the definition of who is an individual with a disability, we get that through the ADA. And it expanded the coverage. So eligibility language was broadened to err on the side of coverage. They expanded the definition of a major life activity. They included impairments that are episodic or in remission. Again, that's kind of or has a record of such a disability. Mitigating measures, except eyeglasses, cannot be considered in eligibility determinations. We're going to get into that a little bit more specifically here in a moment or two. And then they determined that substantial limitation was more appropriate. It lowered the lowered the bar, and determined instead that you know, the previous language of significantly restricts was too high. So a substantial limitation is now how we determine whether or not they are an individual with a disability. As it stated before, so a mental or physical impairment that substantially limits one or more major life activity. So what is a major life activity? Just about everything, okay? Caring for oneself, walking, seeing, speaking, learning, breathing, sleeping, standing, lifting, reading, concentrating, thinking, communicating, working, helping, eating, bending, operation of a major bodily function, and the all-encompassing other. Okay, so if there is some sort of a major life activity, you know, just about anything you do on a daily basis could be seen as a major life activity. One thing that is important to note regarding Section 504 plans in schools is it does not have to impact a student's ability to learn, okay? So learning, speaking, reading, thinking, concentrating, communicating, it doesn't have to be related to that. If a student is in a wheelchair and they can't walk, but they get straight A's, they would still have protections under Section 504, okay? So the major life activity in schools can be any of these. It doesn't have to be related to learning. So sometimes there is confusion. Again, the definition, mental or physical impairment that substantially limits one or more major life activities. So what's an impairment versus a disability? More people have impairments than disabilities, okay? The difference lies in the effect that the impairment has on a person, okay? If the impairment causes a substantial limitation of a major life activity, it equals a disability. If it does not substantially limit the person in a major life activity, it is an impairment, and that is not covered under Section 504 or the ADA. So a good example of that is I have an ankle that doesn't work very well sometimes. It creaks a little bit. It gets a little bit sore occasionally. It was a whole fiasco of me falling off an elliptical machine. Not one of my finer moments, but kind of twisted the old ankle. Was young and stupid, never got it checked out. And so now it's just kind of a little wonky. All right. I can walk, I can run. I don't necessarily run ever, but I could if I needed to. My ankle is not going to stop me from doing that. So again, it hurts a little bit. It doesn't work quite right. However, it does not substantially limit my ability to walk, run, climb stairs, do anything like that. So that's an impairment. It's not a disability, okay? So our last kind of part, mental or physical impairment. So we just went over impairment that substantially limits one or more major life activities. So we've gone over major life activity. We've gone over the impairment piece. And then, so what's substantial limitation? Well, very helpfully, as they often do in the law, there is absolutely no definition of what is a substantial limitation. However, we have some guidance from the EEOC that has defined substantially limits as either unable to perform a major life activity that the average person in the general population can perform, or is significantly restricted as to the condition, manner, or duration under which an individual can perform a major life activity as compared to the condition, manner, or duration under which the average person in the general population can perform the same major life activity. That's a mouthful. What does that all mean? Okay, so unable to perform a major life activity that the average person in the general population can perform. So we have a parent who comes to us and says, my student cannot run the length of the gym. They have asthma and they can't run the length of the gym. Okay, well, most people in the average person in the general population can run the length of a gym. Okay, now, if a parent comes to you and says, my child cannot run a marathon because they have asthma. Well, guess what? The average person in the general population cannot run a marathon, okay? So that would not be something, just because your child can't run a marathon, there's no substantial limitation. However, if they can't run the length of the gym, that probably is, okay? Now, significantly restricted as to the condition, manner, or duration, all right? So let's say we have a parent who says, my kid can't run the length of the gym. Well, they can do that, but they have to crawl. Well, that's not the manner in which the average person can do it, okay? Or they can run it, but it's going to take them 15 minutes. Well, no, that's significantly restricted as to the duration compared to another individual, okay? So you can see that there could be these limitations. So somebody's in a wheelchair, well, I can get from here to there without my wheelchair, but it's going to take me longer in a different manner than it would the average individual. Okay, so that's kind of a guide as to what does substantial limitation mean. Determination of a qualification for protections under Section 504, that determination must be made on the basis of an individual inquiry, meaning just because a student has a specific diagnosis or they have a certain quote-unquote impairment does not automatically mean that it substantially limits a major life activity, okay? Or that they qualify for protections under Section 504. What must schools do to be in compliance with Section 504? Some of this stuff is not going to apply specifically to you, but I think it's important to just kind of know what the requirements are. We have to provide written assurance of non-discrimination, appoint a Section 504 coordinator. We need to have grievance and complaint procedures, notice regarding non-discrimination, locate and identify students, very similar to child find under IDEA. We have to notify individuals with disabilities and their parents of the district's responsibilities under Section 504, provide parents with procedural safeguards, and then develop evaluation and placement procedures. So we have to do all of those things. We also have to provide Section 504 students with FAPE, so free appropriate public education. Same definition as under IDEA, not done in the same way, but similar, maybe I shouldn't say same, similar definition. The provision of regular or special educated and related aids and services that are designated to meet individual educational needs of handicapped persons as adequately as the needs of non-handicapped persons are met and are developed in compliance with Section 504 procedural requirements, okay? Free accommodations and services must be provided without cost to the parent. However, fees that are charged to all students may be charged. We can, as long as it's not saying, well, your student needs a large print textbook, and so you have to pay for that. We can't charge them for that. However, if we charge a fee for all textbooks, so every student has to pay $5 for quote unquote textbook fees, we can charge them that, but we can't make them pay for the large print textbook, okay? Just a couple of cases. Lack of funding does not excuse the failure to provide services. So not having money does not excuse you from providing services for students. You can't categorically deny or refuse to consider a particular related aid or service in a particular class. You can't say, well, you're in a honors course, so you don't get the extra 15 minutes or 30 minutes on a test. You can't categorically deny or refuse those. Behavior intervention plans, Section 504 requires this district to accommodate a student's behavioral challenges by developing a BIP. And again, sometimes we get a little confused as, well, isn't a BIP under IDEA? Well, not necessarily. Again, it's the level of supports that are needed, and also the reasoning behind the behavioral challenges. So, but just be aware, we would, under 504, you may need to do a BIP. Failure to implement. The teacher is responsible for implementing the plan, or the teacher that is responsible for implementing the plan did not have a copy of the plan, was not aware of accommodations under the plan, and had no training on the plan. Any student who has a Section 504 plan, that students, all of those students, teachers need to be aware of the plan. They need to know what the accommodations are. They need to be trained if there's something specific. All of those sorts of things need to happen. In my previous job, when I was representing a different school district, we had a situation where a student had a traumatic brain injury and was not supposed to be on the computer to do any sort of assignments or anything like that. Well, state testing came along, and those were all done on the computer. Well, the teacher who was facilitating the state testing, the state assessments, did not know about this student's Section 504 plan. The class showed up, she plopped everybody down in front of a computer, and off they went. He did the test, all of that, but then later found out that he did his test, and mom filed a complaint with the Office of Civil Rights for failure to follow the student's 504 plan. So, you know, that was a specific situation where a teacher who needed to know about the student's 504 plan was not aware of it, and they did not implement it. And again, a failure to inform staff of the student's accommodations, failure to implement a 504 plan, all of this inconsistent implementation can also be an issue. So one of the things that's very important is not only to have a 504 plan if a student needs one, but to also follow the plan and to make sure we're implementing the plan. What role do parents play regarding their child in Section 504? You need written consent for initial evaluation and initial placement, okay? Very similar to IDEA. We cannot initially evaluate a student for a Section 504 protections or a 504 plan, and we cannot place them without written consent, okay? Parents should be included in the evaluation, identification, and placement process whenever possible. Again, we want parents involved. We want their input as much as possible. They have the right to file a due process complaint, the right to an impartial hearing. They have the right to notice of their rights. They have the right and opportunity to examine relevant records, participate in the hearing by the parent and or counsel, and review our procedure. They also have the right to file an OCR complaint. As I mentioned before, the Office of Civil Rights, they're under the Department of Education. They have the right to file a complaint under OCR. Can districts consider mitigating measures used by a student in determining whether the student has a disability under Section 504? So we mentioned this earlier, that the changes to the ADA by the ADAAA, maybe I could just say ADAAA, those changes no longer allow you to consider mitigating measures. So as of January 1st, 2009, see, I told you it was quite a few years ago. I don't even know that I realized it was that long ago. Districts cannot consider the positive effects of any mitigating measures that a student is using in determining whether a student has a physical or mental impairment that substantially limits that student in a major life activity. So mitigating measures include but are not limited to medication, medical supplies, low vision devices, but not including ordinary glasses or contacts, prosthetics, hearing aids, cochlear implants, other implantable hearing devices, mobility devices, and oxygen therapy equipment and supplies. So in determining whether an individual is an individual with a disability, so whether a student is an individual with a disability, has a mental or physical impairment that substantially limits one or more major life activity, we cannot consider mitigating measures. If a student is diabetic, okay, and they need insulin, we cannot consider the insulin in determining whether or not they are an individual with a disability. So if they did not have that insulin, their pancreas would not be able to produce the insulin that they need. And I think that's how it works. I really shouldn't talk medical terms. I don't, lawyer, don't really know all of that, but their body can't function properly without that medication. So if we take that medication away, that substantially limits one or more major life activity. Okay. Same with a wheelchair. Let's say if we take away the wheelchair, I'm not saying we actually take away the wheelchair, but we take away the consideration of the positive effects of the wheelchair, they cannot walk. Okay, so that means that they are considered an individual with a disability under the ADA, and they would have the protections under Section 504. So what does that mean for us? Okay, so it's two different things. So Section 504 kind of does two different things. So one, it's that we can't discriminate against individuals on the basis of the disability, and we have to provide reasonable accommodation so that they have equal access to the general education programs and activities. Okay, so let's say we have that student who has, let's say they have ADD, ADHD, okay? They take a pill in the morning before they come to school, and they take a pill after school. We don't have any medication. We don't take care of anything in giving them any medication or anything like that, okay? Now, we can't consider the positive effects of the ADHD medication, okay? If the student was not taking that medication, they wouldn't be able to concentrate, they wouldn't be able to think, and those sorts of things. There would be a substantial limitation to one or more major life activity, okay? So they would be considered as an individual with a disability. They would have protections under Section 504. However, we may not have to put any sort of reasonable accommodations in place or even have an actual plan in place for them, because as long as they're getting their medication at home that we don't control, they don't need any additional reasonable accommodations, okay? Even if we give them a pill, okay, that may be the entirety of the plan, that they will have access to medication. So it may not have to be any more complex than that. But, same with, hearing aids. A student is going to have the right to use their hearing aid. They may not need anything more than that. But in determining whether or not they qualify or are eligible for protections under Section 504, we cannot consider mitigating measures. How does a medical diagnosis impact evaluation of an impairment under Section 504? No impairment in and of itself is a disability, as we kind of discussed before. It has to be substantially limiting, okay? So a medical diagnosis of an illness does not automatically mean a student can receive services under Section 504, okay? A medical diagnosis is not sufficient as an evaluation for the purposes of providing FAPE. Okay, the 504 regulations require school districts to draw upon a variety of sources in interpreting evaluation data and making placement decisions. You can't just look at the diagnosis. You should probably also look at grades, behaviors, all of those sorts of things. If we have a healthcare plan, do we really need to consider Section 504? Probably so. OCR, the Office of Civil Rights, has taken the position that use of a healthcare plan instead of referring for evaluation under Section 504 allows the school to circumvent the procedural safeguards provided by Section 504. Okay, so as we were going through, I think it was question number 2, I could be wrong, what we're required to do as a district in regards to Section 504, well, there was a provision that we have to provide parents with the procedural safeguards, essentially saying we're not going to discriminate against their student on the basis of their disability. What OCR is saying is if we have a healthcare plan as opposed to a Section 504 plan, we're not letting them know about those procedural safeguards, that they have the right to file a due process, that they can file a complaint with OCR. And so we need to make sure that we're providing them with those procedural safeguards. And OCR goes on to state that Section 504 also covers impairments that are episodic or in remission, where a health plan wouldn't necessarily do that. So that's why a health plan in and of itself would not be enough to take care of our requirements under Section 504. Other potential problems with health plans as opposed to 504 plans is that our child find obligations may not be met. FAPE obligations may not be met because we have to follow notice, evaluation, and placement procedures under Section 504. Individual health plans are mitigating measures, and we can't look at that in determining 504 eligibility. And as we stated before, it can deprive parents of procedural safeguards and non-discrimination protections under Section 504. As I mentioned briefly before, schools focus too much on academic performance and the major life activity of learning. You know, we have to consider all major life activities and major bodily functions. The expansion increases the possibility that students with acute or chronic health impairments will qualify. So we need to be aware of those things. If a student had a health plan prior to the ADAAA amendments, is that sufficient to comply? Again, not necessarily. Even though they may be sufficient to meet the student's needs, the question becomes whether we met our requirements of the evaluation, placement, and procedural safeguard requirements of Section 504. Again, in my previous life as a school attorney with KASB, had a situation with a district that went above and beyond into providing accommodations for a student that had a disability. Parent got upset, filed a complaint with OCR, and what OCR essentially said was, yes, you're doing absolutely everything you should be doing for this student and more, but you didn't follow the process. You didn't give the parent the rights, the procedural safeguards, their rights under Section 504. You didn't essentially jump through the hoops that you need to in ensuring that you're complying with Section 504, and the district got dinged for that. So it's really important we follow the process. Example, a peanut allergy health plan. So we would have to evaluate whether the peanut allergy would be substantially limited to life activities without considering medications or an EpiPen. So you have a student with a peanut allergy who has an EpiPen, but we can't, consider that. So if they were to come in contact with a peanut and they didn't have their EpiPen, would that substantially limit their ability to breathe? And if the answer is yes, they would qualify as an individual with a disability. If a student is believed to need special education or related services, you have to go through an evaluation and process and procedural safeguards under Section 504. So that's a little bit confusing, but if a student has an IEP for a peanut allergy, OHI, with a peanut allergy, they would have the anti-discrimination protections under Section 504. However, you would not write a 504 plan because you would have the IEP. Okay, you would never have a 504 plan and an IEP for the same things. Okay, now there could be a situation where a student has an IEP and a 504 plan. Let's say they have an IEP for um, autism, and they also happen to be diabetic. If the diabetes would not rise to the level of an OHI, it could be possible that the student would have both an IEP and a 504, but you would not have an IEP and a 504 both for the diabetes. Again, when does a student with a health plan need to be referred for a 504 evaluation? Degree of severity of the health condition, degree of complexity of the health plan, risk of medical emergency at school, severity of potential consequences of a medical event at school, frequency of implementation of the health plan, need for accommodations and services in the classroom, need for health plan implementation, students' classroom performance, including PE. Again, if you're looking at writing a health plan, you should seriously be considered writing a Section 504, or at least looking at Section 504 before you go into a health plan. What is generally required during the Section 504 process? So here's a little chart. You refer to an early intervening or 504 team, so parent or teacher suspects a disability. They complete the referral form and give it to the principal. Then we get the notice and consent. We then do an evaluation, have a meeting, identification, determination, and then an annual review and 3-year evaluation. So the word evaluation can get really confusing to school personnel, because when we hear about an evaluation of a student, we automatically think of special ed evaluations, which are much more in depth than a 504 evaluation may be, okay? You can use the same process to evaluate the needs of a student under Section 504 as under IDEA, but you wouldn't necessarily go through the same testing. The Section 504 team should draw from a variety of sources in the identification determination process so that the possibility of error is minimalized. The information obtained must be documented, and all significant factors related to the student's learning process must be considered, including aptitude and achievement tests, teacher recommendations, physical condition, social and cultural background, and adaptive behavior. If we're looking at purely a physical disability, some of this stuff, you may not have to go this in depth in things. It may be a situation where if it's merely physical, of a situation of getting some information from a healthcare provider, and then also some input from teachers about mobility, how they're able to get around, and those sorts of things. So you may not necessarily get into aptitude and achievement tests and those types of things. Factors to be considered for the planned service options by Section 504 team include evaluation results, 504 identification determinations, what the unmet needs are, services and or accommodations based on needs, what the least restrictive environment for services are, and discussion of and plan for possible staff training. Implementation, Section 504 makes decisions regarding necessary accommodations and services to allow for the student's disabilities. Parents should be consulted and give them the opportunity for input. You should have a 504 case manager assigned to coordinate the student's plan. Review and reevaluation, there's nothing in the Section 504 regulations that specifically state when you have to do a review or a reevaluation. However, the Office of Civil Rights has stated that if you are in compliance with the IDEA regulations, so 1 year and 3 years, that you are compliant with the 504 regulations. So that is what we recommend. So what's in the law is that periodic reevaluation is required. If you conduct it in accordance with IDEA, you're good. You can do it more frequently if it's warranted. So you have a student who is currently undergoing chemotherapy treatments because of cancer, and you have a 504 plan that is in place while the student is actively receiving treatment. You come back the next year, they're done with treatment, So we need to do a reevaluation before the three years is up, because the student's circumstances has changed. So that would be a time where doing it more frequently would be warranted. What are the common pitfalls schools fall into regarding Section 504? One of the big ones is when a student is evaluated and does not qualify for special education services under IDEA. At that point, you may want to look at a Section 504, because if they don't qualify for special education, but we were looking that there was some sort of a situation or an impairment or a disability that was causing some struggles, if we don't qualify for SPED, we should look at 504. If a parent frequently expresses a concern about their child's performance, anytime retention is being considered, if a student returns to school after a serious illness or injury, if a student exhibits a chronic health condition, even if they don't have a diagnosis, again, as we talked about before, a diagnosis is not necessary for a 504 plan. But if you have a student, I had a situation with a school one time where, you know, a student was at the Mayo Clinic, were flying all over the country because they had this mysterious illness, and they couldn't quite get a diagnosis for the student. The student was missing a lot of school, and the principal said, well, I'm just going to drop him from school because he's never coming. And I said, whoa, time out. You know, we have a student who's flying all over the country because of a health condition. We really need to be looking at a 504 plan, because again, even if we don't have a diagnosis, we know that they're struggling with some sort of a mental or physical impairment that's substantially limiting one or more major life activities. So, and again, as you know, in that definition, there's nothing that specifically says it has to be identified as a specific diagnosis or a specific disease. And then when a disability of any kind is known or suspected, would be times that we really should be thinking Section 504. So really, what do I have to know about Section 504? I am not under the impression that any of you are going to become absolute experts in Section 504. That's one of the things that's really great about having an attorney on staff, also having a Section 504 coordinator, is that we are the people that need to know the ins and the outs of the law. What I need you to know is what you don't know. I need you to know, we have this student who just, you know, they keep calling the student in sick, but, you know, I don't know what's going on. I haven't, you know, those sorts of things. Any sort of things that just kind of make you go, that seems a little different. Any of these sorts of red flags, you need to be thinking Section 504. What's really important, Section 504 plans are required by law, just like an IEP. Failure to follow Section 504 plans or Section 504 rules will lead to liability for the district. And also, 504 includes anti-retaliation provisions. You can't, you know, retaliate against a student for getting accommodations. That's another situation. I had a situation with a teacher, not in this district, who kept giving a student a 0 for participation points in PE because the student had a physical impairment that kept them from participating. So the teacher kept giving the student 0s for participation. You can't do that. It's not allowed. Be proactive. Recognize that Section 504 is not something you can ignore. Get the facts. You know, anytime we're dealing with intervention teams and those sorts of things, eventually we could be looking at a Section 504 plan. But again, call myself, call our 504 coordinator for advice, ask questions. We're happy to talk through things with you, but just make sure you ask questions, because it's much easier to fix things on the front end than on the back end. So If you have any questions about Section 504, any of the materials that we went over today or anything, do be aware that we have a Section 504 handbook. It answers a lot of questions. It's a really good resource. It has forms in it that you may need, all of those sorts of things. So just be as proactive as you can be in addressing some of these situations. But if you have questions, certainly feel free to contact me. I appreciate you taking the time. I hope you enjoy the rest of your day, and thanks again.